So, right, clients don't come in with a list of issues clearly.
They come in with a problem.
Right, and they just...
And they tell you what they want to tell you. And then you have to figure it out.
Right. Welcome to all our viewers here. We're at the Media Reporter at New York Law School, and we're talking today with Professor Ross Sandler and his wife, Alice Sandler. And we're discussing Professor Sandler's new book, Jumpstart Torts, which came out in March 2012, and we're really glad to have you here. So thank you for coming in and talking to us. So we've been talking a little bit before, but I really wanted to discuss with you what made you write a book in this format for your students.
I've been teaching torts at New York Law School for 20 years. And when I first started, I thought, boy, I'd really nailed it. The students got it. And then I get the exams and they were confused. And I tried to figure out why they were confused. And what I realized was that torts is taught to first-year students. They come in that August, they know they have not taken civil procedure, they don't know about law, and they need help to understand what it is they're supposed to learn. So then I started drafting my own materials to help students understand how to begin reading cases, how to think about law, how to understand the vocabulary. And it evolved into this, to Jumpstart Torts. At first we called it the language of law. And the idea being that it's a new vocabulary, it's a new language, new use of words. Often similar words you use in ordinary speech have different meanings. So it was very important to think about that. And the combination of language and legal analysis led to Jumpstarts. And what it is what you need to know in order to begin to know what to study and what to write about in torts.
Right. And it's not just torts. I think that the principles that you go over and you outline for your readers are applicable across the board in any legal
application. Well, they are true. That is true. But torts in particular, because torts is all about litigation.
Right.
It's about injury law. You have an injury, usually between strangers. They don't have a prior relationship. So all you have is this injury event. And that then goes to litigation and all the courtroom procedures, all of the issues about complaints and answers and motions for summary judgment, all that is in play, and it's almost impossible to understand the judicial decisions that law students are asked to read from day one unless you understand that this is about court procedure, and that's what this teaches.
Right. I wish I had had this book as a tort student.
Well, you can start again. You want to start again?
Well, I have been. I've been thinking I can at least use this for the bar exam. So.
Well, good. And tell your friends.
I will. I will. And for all our viewers, it's available on Amazon.com. Again, it's called Jumpstart Torts. And I think that what's really interesting, Ms. Sandler has helped you with this, and your background as an educator really comes through, because this is unlike most case books in that it really breaks down step by step what is required of students to do well on an exam. And so I wanted to ask you, what did you know that from what you had seen, you've seen a case book, you've probably seen thousands of them, and you realized that a little more needed to help students, or did you?
Just in talking with Ross and in conversation and hearing what his students needed and hearing that the difference between a plaintiff and whatever the other defendant is, you know, you had to get those cast of characters,
right? Exactly.
and all the parts together, and you had to learn what each one was. And so Ross and I would talk about it together, and eventually he really did it.
I would write stuff, and then Alice would read it and say, well, I don't understand this. What does this word mean here? And so we'd have to go back. And so what Alice contributed a lot was what a good editor does, which is to say, you could make this clearer. You could write this so that people understand it better.
Right. And that's what's really stands out most to me, is that a layperson, not even a law student, could look at this and it would start to make sense, just because it's so step by step. It guides you, whereas a casebook just gives you the opinion and you're asked to make sense of it.
Well, what I looked at all the casebooks, and they all start off with maybe 10 pages or 15 pages where they try and tell the student, well, let me tell you what you're going to be learning here. And then you read that, and it's so dense, and it's so without examples, and so quick that it's almost unhelpful.
Right.
And then I suspect that what professors do generally is they say, read that, and we'll talk, and they don't talk about it. or they come back to it class by class, and so you spend a lot of time covering this kind of material too late in the term. So I think it's very important to get it early,
right,
and then get it later, both early and later. Early because it gets you going, and later because you really understand it then.
Right, exactly. And that's what Jumpstart Torts really helps with. The glossary and the appendix breaks down what every word means and how to use it without a 4-sentence definition, which you sometimes find and actually isn't very useful because it's just more to memorize.
Well, I wish students would look at the dictionaries more, but they don't. And so they come across words, or they think they understand a word. For instance, a term like summary judgment, that's understandable. It's a judgment and a summary, meaning that it's without a trial. People understand that. But what's behind that term is an enormous amount of knowledge, standards, procedures. And so you have to get all of that, because otherwise it's a code that students can't break.
Right.
You need to break down these words so it can be understood and then used.
Right. And it's impossible to use these words on an exam without having an understanding all year round, and I think that's what this is. We were just discussing before, this shouldn't be a book that you buy 2 weeks before the exam. It could actually help you throughout the semester before.
Well, we included an exam in it. The publisher thought it'd be a good idea to actually include an exam, so I took one of my exams and I adapted it and a rubric that I'd actually used, and then I went to the students who had turned in their exams, and I took one that was very good and one that was not quite as good, and I then put them in the book, and then I commented on each one of them in the margins as to why this one was good, why this one wasn't so good. And one of them, there were two plaintiffs, and they were different, had different fact patterns, and the exam that wasn't quite as good, the student had combined them. And so we missed all sorts of issues because they were in two different situations. So that's the kind of thing that students don't necessarily get.
Right.
Another thing, students they like to write like lawyers, so they use things like a P and a D for plaintiff and defendant, and they use acronyms. And it turns out that that doesn't work so well in an exam, and it's obvious when you read it that they get mixed up.
And I think that also one of the valuable parts of this book is the exam grading rubric, where you really show where points are lost and made, and how to structure your answers in a way that can get you an A.
Well, most professors give out their old exams. Okay. So a student can look at an old exam and say, well, let me try and answer it, and then they may work together in a study group, and they answer the old exams. What most professors don't give, or many don't give, is an actual rubric on how they will grade it. So the student not only knows what the exam is like, but what the grading sheets will look like. So that's part of what other professors do it differently, but I do it with a rubric, very formal, and that way you need a rubric. A rubric is simply a grading sheet that tells you what you're looking for. Then you can use that to indicate whether what you find in the paper is there. I find it useful because you grade papers over a relatively long period of time, maybe over